Judge Loyal Mercer died holding a 4-year-old boy against a concrete wall while the second cell came through. He was 84 years old. The governor came to the funeral. 4 television stations came to the funeral. His will left one item to a woman named Hattie Rowe Bell. Not money, not land. A desk. She was 80 years old, and she had seen that desk exactly once in her life, in November of 1968, through an open doorway, from a bench in the hallway, while her father stood at the counter with a piece of paper he had written in pencil and $1.25 in coins. She was not allowed to read his letter until she had stood up in open court and answered. The storm came through Talcott County, Alabama, on the 14th of March at 20 minutes past 9 in the evening. It was on the ground for 4.5 miles. It crossed Route 27, took the roof off a tractor dealership, and then turned north and went straight down Coffee Branch Road, where there was a mobile home community of 19 lots and no basement anywhere on the property. Loyal Mercer was 84 and had been retired from the bench for 9 years. He was at the volunteer fire station on 3rd Street when the call came, because he had kept the habit of coming by on Friday evenings to make the coffee, and had kept it for 30 years, and nobody had ever asked him to. He got in his own truck and went. He was 4 minutes ahead of the engine. He brought 4 people out of Coffee Branch Road. A woman named Charlene Fenn and her mother out of Lot 6, 2 brothers out of Lot 14. Then somebody on the road told him there was a child still in Lot 11, and he went back a 5th time. They found them the next morning under a section of block wall from the laundry building. The judge was on his knees with his back to the wall and the boy underneath him. The boy's name was Isaiah Fenn. He was 4 years old. He came out of it with a broken collarbone and 1 shoe. That is the man they buried. That is the entire difficulty of this story, and there is no way around it, and anyone who tells you it is simple is telling you something else. Truett Amos had been Loyal Mercer's lawyer for 31 years. He was 76. He read the will in the front room of the house on Ivy Chapel Road on the Monday after the storm, with both of Mercer's daughters present and the grandchildren sent out to the porch. The estate was ordinary. A house, a barn, a truck, some certificates of deposit, a rental duplex in Cordell Springs. It went to the daughters, split even, the way everyone expected. Then Amos got to the 9th paragraph and stopped, and read it once to himself before he read it out loud, which is a thing lawyers do not ordinarily do. The 9th paragraph left one specific item of personal property, a wooden clerk's desk, oak, 3 drawers on the left and 3 on the right, currently stored in the barn, to a woman named Hattie Rowe Bell of Salis Road. There were 2 conditions attached, written in Mercer's own hand above his signature. She had to accept it in open court, not by mail, not by signature, not through a lawyer, in the probate hearing, on the record, standing up. And there was a sealed letter, and she was not to open it until she had stood up and answered. Claudia Mercer Spate, the older daughter, said, "Who is Hattie Rowe Bell?" Truett Amos said, "I don't know." That was true. Mercer had brought him the paragraph already written, in 2021, and had asked him to make it fit inside the document, and had not answered a single question about it. Amos had argued with him. He said so afterward, plainly, because he was the kind of small-town lawyer who does not see the point in being clever after the fact. "I told him a will disposes of property," Amos said. "I told him he could not use it to make a woman stand up in a courtroom, and he said, 'I'm not making her.' If she says no, that's an answer too, and it will be the right one." Amos asked him what was in the envelope. Loyal Mercer said, "Something I owe." Amos asked him why he did not simply drive out there and hand it to her, which was the obvious question, and which took about 4 seconds to ask. And Loyal Mercer, a man who had been elected 4 times, who had sat on that bench for 34 years, who could stand in front of a county commission and hold a room without raising his voice, sat in that office and did not answer it. He changed the subject. He asked about Amos's wife. Amos let it go, the way you let things go with a friend. 5 years later, he was standing in a front room with an envelope in his hand and no idea what was in it. To understand what happened in that courtroom, you have to go back 57 years, and you have to understand what a piece of paper was worth in Talcott County in 1968, and to whom. Ezra Bell was 61 years old that fall. He had a fourth-grade education. He could read, slowly and carefully, and he could write in a large square hand, and he was better with numbers than anybody in his family, which is how he had come to own land at all. The land was 214 acres on Coffee Branch. His father had bought it in 1903 on a 15-year note and had died before it was paid, and Ezra and his brothers had finished paying it in 1911, and there had been a supper at the church that year that people still mentioned 60 years later. It was not good land. It was ridge and bottom, 40 acres you could plant and the rest in pine and hickory. It ran along the creek for 1.25 miles. It was worth, in 1968, perhaps $11,000, and it was the only thing his family had ever owned outright in this country. On the 9th of November, 1968, Ezra Bell drove 14 miles into Cordelly Springs with a piece of paper folded in quarters in the breast pocket of his coat. He had written it himself in pencil on a sheet of lined tablet paper. It said that upon his death the 214 acres on Coffee Branch went to his daughter Hattie, because his 2 sons had gone north and had said they did not want it, and because Hattie had stayed. 2 men had signed it as witnesses, a neighbor named Emmett Sturdivant and Ezra's own pastor. Hattie Rowe Bell was 22 years old and drove him in, because his eyes were going. She waited on the bench in the hallway outside the probate office because that was what you did, and she watched her father through the doorway. He took his hat off. He laid the folded paper on the counter and smoothed it flat with the side of his hand, twice, the way a man does with a thing he is not sure will be taken seriously. The deputy clerk behind that counter was 26 years old. He took the paper. He looked at it. He wrote out a receipt and stamped it and took the $1.25, and Ezra Bell put the receipt in the same breast pocket the will had come out of and put his hat back on and came out into the hallway and said to his daughter, "All right, that's done." It was never entered into the record. Not destroyed, not lost, not stolen. It went into the bottom left drawer of the clerk's desk in the record room with the rest of the afternoon's work. And the drawer was closed, and the next morning Loyal Mercer came in and did his job and did not open it. That is the whole of it. That is the entire crime, and it took 4 seconds, and it was made of nothing. Ezra Bell died in June of 1971 at the age of 64. There was no will on file. As far as the record of Talcott County was concerned, he had died without one. What that means is not obvious to most people, and it is the reason this story exists, so it is worth saying plainly. When a man dies without a will, his land does not pass to one person. It passes to all of his heirs at once, in undivided fractional shares. His children get a share each. When a child dies, that share splits again among their children. Nobody owns a particular acre. Everybody owns a fraction of every acre. Lawyers call it heirs' property. In 1971, Ezra Bell's 214 acres had 4 owners. By 1983, it had 48, spread across 6 states, most of whom had never seen it. Hattie Bell lived on it, farmed the 40 acres of bottom, paid the taxes out of her own pocket for 12 years, and could not do one single thing with it. She could not sell it. She could not borrow against it, because no bank will take a fractional undivided interest as collateral. She could not get a federal farm loan, for the same reason. She could not put a roof on the house without paying cash. And there was one more thing she could not do, and she did not know it until 1983. She could not stop it. Under the law of the state of Alabama as it stood at that time, any co-owner, any one of the 48, holding any fraction, however small, could petition the court to force a sale of the whole tract and divide the money. In March of 1983, a company called Cusetta Timber bought a 1/48th interest in the property from a man named Otis Rowe, who was Hattie's second cousin, who lived in Dayton, Ohio, who had never set foot on the land, and who was 61 years old and had a wife with a heart condition and no insurance. They paid him $400. In June, they filed a petition for partition by sale. The hearing took 11 minutes. There was very little for anybody to argue about. The law was the law. The property could not be physically divided in a way that gave 48 owners anything usable, and when it cannot be divided, it is sold. Hattie Bell had a lawyer for 2 hours, which was as much as she could pay for, and he told her the truth, which was that there was nothing to be done. The sale was held on the courthouse steps in Cordell Springs on the 6th of August, 1984, at 10 o'clock in the morning. Hattie Rowe Bell was 38 years old. She stood in the third row of people on the steps. Her son Ray was 19 and stood next to her and did not say anything the entire time. The property sold for $61,000. It was worth, by any appraisal anybody has run since, somewhere between 3 and 4 times that. Forced sales do not bring market value. They never have. Everybody in that business knows it, and it is not a secret. Cusetta Timber was the buyer. Here is the arithmetic, and it is the part people remember. Out of $61,000 came the court costs, then the commissioner's fee, then the attorney's fee for the petitioning party, which under the statute came out of the proceeds, meaning that the family paid the lawyer who had brought the action against them. Then the title work, which was extensive, because 48 owners had to be identified and traced across 6 states. What was left to divide among the Bell heirs was $4,100, divided 48 ways. Hattie Rowe Bell received a check for $85.40. She has kept it. She never cashed it. It is in a brown envelope in a cookie tin on top of her refrigerator, and it is in that tin with one other thing, which is a receipt from the Talcott County Probate Office dated the 9th of November, 1968, in the amount of $1.25. The presiding judge at the partition sale was Loyal Mercer. He had been appointed probate judge of Talcott County in January of 1983. Hattie Bell had no idea who he was. She had seen him once, from a hallway bench, 16 years earlier, and she had been looking at her father. People hear she lost the land, and they hear a sentence. It is worth being specific about what it actually took. She lost the house. Not immediately. Cusetta Timber let her stay 11 months, which was decent of them, and which she has always said so. She moved in July of 1985 into a rented place on Salis Road with a tin roof and 2 bedrooms, and she was still in it 41 years later, because she never got in front of it again. She lost the farming. There was nothing to farm. She went to work at the turkey processing plant in Cordell Springs in September of 1985, on the line, second shift. She was 39 years old. She stayed 19 years. She retired in 2004 with a pension of $611 a month, and she has said, more than once, that the plant treated her fine and that she is not going to stand there and complain about the only job that ever kept the lights on. She lost her son. Ray Bell was 19 on those courthouse steps. He stayed home through that fall and the winter and most of the next year, and in November of 1985, he got on a bus to Detroit. He was 20. He got on with a machine shop in Warren and stayed with it 34 years and became very good at it. He came home in 1996 when his grandmother died. He was in the state of Alabama for 4 hours. He went to the church, he went to the cemetery, and he got back in a rental car and drove to the airport in Birmingham, and his mother stood in the parking lot of Shiloh Grove Baptist Church and watched him do it. He has 3 children. Hattie Bell has met all of them. 2 of them she has met on a telephone screen. She has never once said that Ray was wrong to go. She has been asked, and she says the same thing every time in the same flat voice. He was 19, and he stood on those steps and watched it happen, and there was nothing he could do about it. Then he found a place where a thing like that couldn't happen to him. I'm not going to sit here at 80 years old and call that a mistake. And she did not get anybody to look at the receipt. That is the part people find hardest to believe, and it is the most ordinary part of all. She showed it to 3 lawyers over 41 years. The first in 1985, the second in 1994, the third in 2003. All 3 of them told her the same thing, and all 3 of them were correct. A receipt proves that Ezra Bell filed something on the 9th of November 1968 and paid $1.25 for it. It does not prove what? There is no copy. There is no index entry. That is the entire problem, that there is no index entry. And a court is not going to unwind a partition sale that closed in 1984 against a purchaser who bought in good faith on a receipt with no document attached to it. The third lawyer, in 2003, was kind about it. He was young. He said he was sorry, and he meant it, and he told her that if the document ever turned up, it would be a different conversation entirely. Hattie Bell said, "Where would it turn up?" And he did not have an answer for that, because there wasn't one. She stopped asking after that. She was 57 years old, and she had asked for 18 years, and she put the receipt back in the tin. In October of 1991, a private land surveyor named Del Crawford was hired by Casita Timber to rerun the boundary on the Coffee Branch tract, because a fence line on the north end did not match the deed, and somebody wanted to know why. Del Crawford was 45. He had opened his own office 2 years earlier and had 4 clients and a truck he was still paying on. He went to the record room in the Talcott County Courthouse to pull the old plats, and the plat drawer stuck, and he opened the bottom left drawer of the clerk's desk instead, because it was the only other drawer in the room deep enough to hold rolled maps. There were no maps in it. There was a stack of paper about 4 inches deep, unsorted, some of it in envelopes and some of it loose, and on the top of it was a sheet of lined tablet paper folded in quarters, and Del Crawford unfolded it because a surveyor unfolds things. It was a will. It was written in pencil. It was witnessed. It described 214 acres on Coffee Branch by meets and bounds that he recognized immediately because he had been walking that boundary for 2 weeks. It was dated the 9th of November, 1968. Del Crawford carried it up the stairs to the judge's office and knocked on the frame of the open door. He has told this part 4 times now, and it does not vary. And the reason it does not vary is that he has been telling it to himself since 1991. He said, "Judge, I found this in the desk downstairs. I don't believe it ever got recorded. I'll walk it down to the counter this afternoon and get it entered." And Loyal Mercer, who was 49 years old and 8 years on the bench, stood up from his chair and came around the desk and took it out of Del Crawford's hand. He did not say, "Don't bother." He did not say, "I'll handle it." He did not say anything at all that could be repeated afterward in a sentence with quotation marks around it. He unfolded it and read it, and Del Crawford watched him read it, and it took about 20 seconds, and there was no expression on his face of any kind. Then he folded it back along the same creases and said, "Thank you, Del." And he opened the drawer of his own desk and put it in, and closed the drawer. Del Crawford stood there for a moment. Then he said, "All right, Judge," and he went back down the stairs. He has been asked why. He is 79 years old now, and he is on oxygen, and he does not soften it. I was 45, and I had a 2-year-old business in an 11,000-person county, he says. That man signed off on every plat I filed. He appointed the commissioners on every partition in that courthouse. I told myself he was going to handle it, and I told myself he knew the law better than I did, and both of those were true, and neither of those is why I walked down those stairs. He was asked what the reason was. "I didn't want to know," Del Crawford said. "That's the reason. I had it in my hand, and I gave it to him, so I wouldn't have to be the one holding it." He never asked again. He worked in that courthouse for another 24 years. On the Tuesday after the storm, Del Crawford heard at the feed store on Route 27 that Judge Mercer's will had left something to a woman named Hattie Rowe Bell out on Salis Road, and he went home and sat in his chair with the oxygen line in his nose for about 2 hours, and then he looked up her number and called it himself. He did not explain on the telephone. He said, "Mrs. Bell, my name is Del Crawford, and I surveyed in this county for 40 years, and I need you to come out to my house." And when she came up his front walk 2 days later with a folder under her arm, the first thing he said to her, before she had gotten one word out, was, "I have been waiting 34 years for somebody to knock on that door." Claudia Mercer Spate was 54 years old and had been the probate judge of Talcott County for 9 years. She had run for her father's seat in the special election after he retired, and she had won it, and she had won it again 4 years later, and there is a certain kind of county where that is simply how it goes, and nobody thinks anything of it, and Talcott is that kind of county. She found out who Hattie Rowe Bell was on Monday afternoon, and it took her about 90 minutes, because in a county of 11,000 people it takes about 90 minutes to find out anything. She did not find it out from a file. She found it out from a woman named Reba Sturdivant, who was the granddaughter of one of the 2 men who had signed as witnesses in 1968, and who answered her telephone and told her the whole of it in about 4 sentences, and who was not gentle about it, and who had no particular reason to be. Claudia Spate sat in her own front room for 3 hours. Then she got in her car with a sealed envelope in her purse and drove 22 miles out to a small house with a tin roof on Salis Road. Hattie Rowe Bell opened the door and knew exactly who she was, because Claudia Spate's photograph had been in the county paper 4 days running, standing behind her sister at the graveside. Neither woman said anything for a moment. Then Hattie Bell stood back from the door and said, "It's 94 degrees out there. Come in." They sat at the kitchen table. Hattie poured 2 glasses of tea because that is what you do. Claudia Spate did not touch hers. "I'm going to say all of it at once," she said, "because if I stop, I'm not going to start again." "All right. My father's will leaves you a desk. There's a letter with it, and it's sealed, and I have not opened it, and I'm not going to. The will says you have to accept it standing up in open court, and you're not to read the letter until you have." She put the envelope on the table between them. "I found out about you at 2 o'clock this afternoon. I want you to understand, I'm not saying that so you'll feel sorry for me. I'm saying it because I've had 6 hours to get ready for this conversation, and you've had 41 years, and I'd rather you know which one of us is behind." Hattie Bell looked at the envelope and did not touch it. "Now here's the next part," Claudia said, "and it's the part I need to say before you hear it from anybody else, because if you hear it from somebody else, I'm finished with you before I start." She put both hands flat on the table. "That desk is a clerk's desk out of the record room. It's the desk my father worked at in 1968. He bought it at the county surplus auction in 1998, and he's had it in his barn 27 years, and I have walked past it, I would guess, 400 times. All right. And the seat I sit in now is his seat. That drawer, whatever's in it or isn't in it, it was in my building for the first 9 years I was in it. I sat about 15 feet from where it used to stand every working day, and I never once thought about it." Hattie Bell said, "Did you know?" "No, ma'am." "Then why are you telling me all that?" And Claudia Spate said, "Because I didn't know is exactly what my daddy leaned on for 57 years, and I'd rather say it out loud at your table than have it be the thing I lean on." There was a long quiet. The window unit came on. "Mrs. Spate," Hattie said, "can I ask you something?" "Yes, ma'am." "Why did you drive out here? You could have had a lawyer mail it. That's what people do." Claudia Mercer Spate looked at the table for a while. "I have been sitting in my house since Monday, trying to work out how a person gets to be the way my father was," she said. "And the only thing I've come up with is that it starts with not driving over." Ray Bell drove down from Detroit on the Thursday. 16 hours. He was 61 years old, and he did not fly, because he does not fly, and he never has. He sat in the same kitchen chair Claudia Spate had sat in and told his mother not to do it. Not out of mercy, he said. Let's be clear. I don't have any for him. Then why? Because of what they'll make you into. He had his hands around a glass he wasn't drinking. That man died holding a 4-year-old. That is going to be on the television again the day you stand up. And every single story about what you say is going to be the woman who ruined the hero's funeral. Every one. And you'll be 80 years old, and that'll be what you are for whatever's left. That's not the same as saying it's wrong. No, ma'am, it's not. He looked up at her. I watched you be one thing for the rest of your life already. I stood on those steps in 1984, and I watched them turn you into the woman who lost her daddy's land, and I watched this whole county decide that was who you were, and I could not stand it, and I got on a bus. And I have thought about that bus every week for 41 years. His voice did not go up. I'm not doing it twice, Mama. I'm not watching it twice. Hattie Bell listened to all of it, all the way through, without moving. Then she said, You were 19. Don't. You were 19 years old, and you stood next to me on those steps, and there was not one thing on this earth you could have done, and I let you carry it like there was. She had her hands folded in front of her. I never once told you that. 41 years. I told myself you knew. Ray Bell put his hand over his eyes. I'm saying it now, his mother said. In a kitchen. Badly. But I'm saying it. They sat there a while. I still don't want you to do it, Ray said. I know. Are you going to? I don't know yet, said Hattie Rowe Bell. I haven't opened it. She drove out to Del Crawford's place on the Saturday. He lived in a brick house on Quarles Road with a carport and a concrete ramp somebody had poured for him. He was 79, on oxygen, sharp as a tack about 1991, and considerably less sharp about last Tuesday, which is how it goes. She sat down across from him, and he told her the whole of it, and it took 9 minutes, and he did not leave himself out of it anywhere. When he got to the part where he walked back down the stairs, he stopped and looked out the window for a while. Mr. Crawford, Hattie said, can I ask you something? You want to know what else was in the drawer? Yes, sir. It wasn't just your daddy's, Del Crawford said. That's the thing I've had in my head since 1991 and never said to a living soul. That drawer was 4 inches deep. There were envelopes in there with rubber bands gone to powder. I saw a deed with a 1961 date on it before I ever got to your daddy's paper, and I put it back because I was looking for maps. He turned back from the window. I don't know what was in there. I want to be honest with you. I saw 2 of them, and I unfolded one. But it was not one piece of paper, Mrs. Bell. It was a stack. Hattie Rowe Bell sat very still. Why are you telling me now? She said. And not in 1991. Because in 1991, the man was on the bench, Del Crawford said. And I was 45 and I was a coward. And there's no better word, and I've had 34 years to find one. He looked at her. And because I read in the paper he left you something, and I thought, well, if he's finally decided to open his hand, then I don't have any business keeping mine shut. She opened it at 11 o'clock at night at her kitchen table, alone, with the window unit running. It was 6 pages, written in ballpoint pen on the backs of 6 old county plat sheets, because that was the paper Loyal Mercer had always had in the house. She read it 3 times. The first page said what he had done. It was specific. It gave the date, the 9th of November, 1968, and the description of the property and the amount of the fee. It said the will was witnessed and facially valid, and that he had known it at the counter. It said he had put it in the bottom left drawer and had not entered it in the index. It gave the second date, too, October of 1991. It named Del Crawford. It said that Crawford had brought it to him and had offered to walk it down to the counter, and that he had taken it out of the man's hand and put it in his own desk. The second page gave his reasons, in the order he had come to understand them, which he wrote had taken him about 30 years. I told myself for a long time that it was the appointment, he wrote. That in 1968 I was 26, and I wanted to be the judge one day, and a 214-acre tract clouded up in one family's hands was inconvenient to a certain kind of man in this county, and I knew which men those were, and I knew who I wanted to be pleased with me. That is a comfortable thing to believe. A man can serve out a sentence for ambition. It has a shape. You can carry it. The truth is smaller, and it is worse. On the 9th of November, 1968, I unfolded that paper on the counter, and I decided in about 4 seconds that it was not a real document. Not that it was invalid. I did not think the word invalid. I thought, this is not the kind of thing that counts. It was pencil on tablet paper, and the man in front of me had a 4th-grade education, and he had smoothed it flat with his hand twice like he was worried about it. I want to be plain, because I have spent 57 years being unplain. I did not build that judgment out of nothing. I built it out of what had been handed to me about people like Ezra Bell since before I could walk, and I had never once in my life taken it out and looked straight at it. He did not fail to file a will. He filed one. I decided it did not count, and I had the drawer, and that was the whole of the machinery. The 3rd page was about 1991, and it was 4 sentences long, and Hattie Bell read those 4 sentences more times than she read anything else in the letter. By 1991, I had been on the bench 8 years, and I had signed the order in 1984, and I knew what I had signed. When Del Crawford stood in my door, I had every single thing I needed: a witnessed instrument, a man willing to walk it downstairs, and the authority to make it right that afternoon. I have told myself since that it was too late by then, that the sale had closed, and the buyer was innocent, and it could not be undone. That is true about the land, and it is a lie about the rest of it. Because that woman was 38 years old in 1984 and 45 in 1991, and I could have handed her the paper and told her what her father did, and I did not, and she has gone the last 34 years not knowing whether he ever went. The 4th page was about what he had done since. He listed things. He had put the first black deputy clerk in that office in 1994. He had pushed the commission in 2009 to fund the digitizing of the deed index back to 1940. He had testified in Montgomery in 2011 in favor of a bill that would have made partition sales harder, which did not pass, and again in 2014 when a version of it did. And then he wrote, I want to be careful not to hand you a ledger. A man does not get to run 20 years of good work and call it square. Those things were worth doing, and I did them, and they are not payment. I know exactly what they were. They were the shape a man makes when he is trying to be a different man in general, so he will not have to be a different man in particular. The 5th page was about the desk. I bought it at the county surplus auction in June of 1998 for $35. I told my wife I wanted it for the barn. The drawer was empty when I bought it, because I emptied it in 1991, and I have had what was in it in a footlocker in my barn ever since, and it is there now, and I have not opened it since the day I put it in. I am not going to tell you what is in it. I have thought about that for a long time, and I have decided I do not have the right to describe it to you. I have described enough things to people in this county. The 6th page was the request. I am asking you to come and stand up in that courtroom, because it is the only room I will ever be able to give you where you have the floor, and I do not. I know what I am doing. I am handing you a loaded thing, and I will not be there when it goes off. I have had 57 years to drive out to Salis Road and knock on your door, and I never found the day, and I have run out of days. And this is what a coward does with the last of them. This is not repentance. Repentance would have been the 10th of November, 1968, and I did not do it. Repentance would have been October of 1991, when a man stood in my door and offered to carry it downstairs for me, and I did not do it. There is no version of this where I get either of those back. It is only the last place I have left to hide, and I am telling you that so you cannot be tricked into thinking better of me than I have earned. Do whatever you want with it. It has been yours for 57 years, and I have been the one holding it. L.M. Hattie Rowe Bell folded the 6 pages and put them back in the envelope. Then she sat at her kitchen table until 3:45 in the morning. She has never told anybody what she thought about during those 5 hours. She was asked once and she said, "That's between me and the Lord," and it took most of the night. The probate courtroom in Talcott County seats 91 people. They moved it to the rotunda. There were 280 people on the floor and up the stairs and on the landing, and 3 television trucks on the square because the tornado story was 3 weeks old and still warm, and somebody had told somebody that there was going to be something at the courthouse. Claudia Mercer Spate could not preside. She recused herself the same afternoon she got home from Salis Road, in writing, and asked for a judge from Chilton County, and a man named Hollis Pate came over and sat. The hearing began at 10. It was ordinary probate business for 20 minutes. Then Judge Pate read the 9th paragraph out loud and asked whether Hattie Rowe Bell was present and whether she accepted the bequest. She stood up. She was 80 years old, in a dark blue suit, and she walked to the front and set 2 things down on the table in front of her. One was the envelope with 6 pages in it. The other was a small brown envelope with a receipt in it, dated the 9th of November, 1968. She did not look down at either one. "My name is Hattie Rowe Bell," she said. "Most of you know me. Some of you have known me a long time." The room got very still. On the 9th of November, 1968, my father, Ezra Bell, came into this building and filed his will at the counter downstairs and paid $1.25 for it. I drove him. I was 22 years old, and I sat on the bench in that hallway and watched him do it through the door. It left me 214 acres on Coffee Branch that his father bought in 1903 and that he and his brothers finished paying for in 1911. It was never entered in the record. She let that sit, exactly as long as it needed to sit. The deputy clerk who took it and stamped that receipt was 26 years old. His name was Loyal Mercer. My father died in 1971, and as far as this courthouse was concerned, he died without a will, and that land went to 48 people in 6 states, and in 1984, a timber company that had bought 1/48 of it for $400 forced it to sale on the steps of this building. It brought $61,000. After the costs and the fees, the family's share was $4,100, divided 48 ways. She picked up the small brown envelope and held it up. My check was $85.40. It is in here. I never cashed it, and this is the receipt, and I have carried it to 3 lawyers in 41 years, and every one of them told me the same true thing, which is that a receipt proves my daddy filed something. She set it back down. In October of 1991, a surveyor named Dell Crawford found that will in the bottom left drawer of the clerk's desk in the record room downstairs. He carried it up the stairs to the judge's chambers and offered to walk it down to the counter that afternoon and get it recorded. Judge Mercer took it out of his hand and read it and put it in his own drawer and said, "Thank you, Dell." Somewhere on the stairs, somebody made a sound. Judge Mercer wrote all of that down himself, in his own hand, 6 pages, and left it to me sealed, and told me not to read it until I stood up here. I read it 4 nights ago. Everything I have said to you is in it, and a good deal more that I am not going to say, because it was written to me. She looked out at 280 people. Now here is what I decided, and I decided it around 4 o'clock in the morning. I am not going to stand in this courthouse and tell you Loyal Mercer was a wicked man, because he was not. There is a 4-year-old boy on Coffee Branch Road who is alive this morning, and everybody in this rotunda knows why, and that is true. What I have just told you is also true. Both of those are true at the same time, and I am 80 years old, and I am too tired to pretend that is a contradiction. It is just what people are. And I am not going to stand up here and tell you I have forgiven him, because I have not settled that. And I am not going to say I have, in front of 3 cameras, to make anybody's Wednesday easier. That is between me and the Lord, and it is not finished." She put her hand flat on the 6 pages. Judge Mercer wrote in this letter that he was giving me the only room he would ever have where I had the floor, and he did not. All right, I have it. I am not going to spend it on a dead man. He is past reaching, and I have nothing to say to him that he did not already say to himself better than I could. And my land is gone. Cuseta Timber sold it in 1997, and there are 42 houses and a water pumping station standing on it, and I am not asking anybody in this room to give me 1 acre of it back, because there is nothing back there to give. She turned slightly. I accept the desk. Yes, sir. I accept it. It has 3 drawers on the left and 3 on the right, and it is sitting in a barn on Ivy Chapel Road, and I would like it brought to my house, and I mean that plainly, and I am grateful for it. But the bottom left drawer of that desk is empty. Judge Mercer emptied it in 1991, and he wrote in this letter that what was in it has been in a footlocker in that same barn for 34 years, and that he never opened it again. And Mr. Del Crawford is sitting in the 2nd row, and he is 79 years old, and he came here on an oxygen tank, and he told me at his kitchen table 2 weeks ago that when he opened that drawer in 1991, my daddy's paper was not by itself in there. He said it was 4 inches deep. He said there were envelopes in it with the rubber bands gone to powder. He said he saw a deed with a 1961 date on it before he ever got to my father's. She looked directly at the bench. Judge Pate, I am asking this court to order that footlocker opened and inventoried, on the record, in public, every instrument in it read out and dated, and the name on it published in the county paper. Not for me. There is nothing in there for me. My paper is 57 years too late, and I know exactly what it is worth now, which is nothing at all, and I have made my peace with that at a kitchen table. I am asking because I have spent 41 years being the only person I knew who this happened to. And I found out 2 weeks ago from a man who has been carrying it since 1991 that I might not be. And there are people in this county right now paying rent on land their granddaddy bought and paid for, and they don't know it, and they are never going to know it, because the only person who could have told them is dead, and the box is in a barn. She stepped back from the table. That's what I want. That is the whole of it. I do not want his name off anything. I do not want anybody's pension. I want the box opened. There is video of what happened next. It runs 11 seconds, and almost nothing occurs in it. Claudia Mercer Spate was standing at the back of the rotunda by the stairs because she had recused herself and had no place at the front. She was not mic'd. People halfway across the floor could not hear her, and she had to say it twice. What she said was, "I'll open it this afternoon." Then she went out the side door and did not come back in, and the hearing went on, and Judge Hollis Pate entered the order at 11:40 that morning. The footlocker was opened on the 18th of April in the County Commission meeting room, with 2 attorneys present, an archivist from the State Department of Archives and History, and 1 camera. It held 41 documents. 9 were handwritten wills, 14 were deeds, 7 were land sale contracts of the kind where a family paid a white landowner in installments over 10 or 15 years and got the paper at the end. 6 were mortgage satisfactions, proof that a debt had been paid off. 4 were miscellaneous. 1 was a deed transferring 2.5 acres to a church. The earliest was dated 1959. The latest was 1974. 29 of the 41 belonged to black families. That number matters, and it also has to be said carefully, because 12 of them did not. And one of those 12 was a mortgage satisfaction belonging to a white tenant farmer named Wendell Coy, who lost 80 acres in 1966 to a bank that had already been paid. What the box actually shows is not a single conspiracy. It is duller and it is worse. It is a drawer that a young man used for things he had decided did not count, and a list of the people he had decided that about. And the list is not exclusively one thing, but it is mostly one thing, and the archivist said so in her report in those words. Of the 41, 11 were still legally actionable in some form. 30 were not. Too much time, too many good faith purchasers, too many deaths. The county recorded all 41 anyway, retroactively, with a notation. The archivist argued for it, and the commission agreed. Her position was that even where nothing can be undone, the record ought to say what happened, because a record that is silent about a thing is how the thing keeps working. The Talcott County Commission took up a broader measure in September. It provides that the county will fund a full audit of unrecorded and misfiled instruments in the probate office from 1950 to 1980, will record every valid instrument found, and will notify the heirs of record at county expense, without anybody having to ask, and without anybody having to know to ask. It passed 5-2. It is not named after anybody. Hattie Robel asked that it not be, and she asked twice, and the second time she was not gentle about it. In the first year, the audit recorded 217 instruments and cleared title on approximately 3,900 acres. None of that land is hers. Her land is gone, and it is going to stay gone. Some things people ask about. The desk was delivered to the house on Salis Road on the 22nd of April by 2 men from the county maintenance department, who would not let her pay them. It is in her front room. It does not fit. She keeps a Bible and a lamp on it, and the receipt is in the bottom left drawer, in the brown envelope, along with the check for $85.40. Del Crawford gave a 2-hour statement to the state archivist in May. He asked that it be made public. It was. He died in November, at 80, and Hattie Bell was at the funeral, in the 3rd row, and his daughter has said that the last thing her father did that could be called work was that statement, and that he was, at the end of it, easier than she had seen him in years. Claudia Mercer Spate did not resign. There was some call for it. She said, publicly, once, that she had not known, that she had also not asked, that these were not the same thing, but that they were closer together than she had thought at 54, and that she intended to be the judge who finished the audit rather than the judge who left before it. She stood for re-election. She won by 400 votes, which is close in that county, and she has said she considers that about right. She and Hattie Robel are not friends. That has been reported a few times, and it is not accurate. And both of them have said so, and both of them have been mildly irritated about it. What is true is that they have eaten lunch together 3 times. The first was hard going. The third was better. By the third, according to Claudia, they had gotten most of the way through the fact that neither of them had chosen any of it, and both of them had been handed it by the same man. She has kept her father's photograph on the wall of her office. She has been asked about that. He was my daddy for 54 years, she says. He did a wicked thing in 1968, and he did a worse one in 1991, when he had every chance to fix it, and he hid it until he was dead, and he was a coward about it to the last week of his life. He also went back into Coffee Branch Road a 5th time. I'm not taking his picture down, and I'm not taking any of the rest of it back. People are going to have to hold both, same as I do. Mrs. Bell said it from that floor before I ever worked out how to say it, and I have been leaning on her sentence ever since. Ray Bell stayed 9 days. That is the longest he has been in the state of Alabama since November of 1985. He rebuilt the back steps of the house on Salis Road, which had needed it for 6 years, and he took his mother to Birmingham to see a doctor about her knee, and on the 8th day he drove out to Coffee Branch Road and stood on the shoulder for a while looking at a water pumping station and 42 houses, and then he got back in the truck. He has been down twice since. He is talking about 3 weeks next summer and bringing the 2 grandchildren Hattie has only met on a telephone screen. He was asked what changed. She stood up, Ray Bell said. That's it. That's the whole thing. 41 years I thought this county broke her on those steps in 84, and I couldn't stand to watch the rest of it. And she stood up in that same building at 80 years old and told the truth about a man everybody loved and didn't ask a single person in there to pick a side. He shook his head. I had her wrong. I had her wrong for 41 years, and I want that on the record. Hattie Robel is 81 now. She still sings in the choir at Shiloh Grove Baptist Church, and she has been on the usher board since 1979. She was asked at a small gathering at a church in Selma what she would say to somebody carrying a thing like hers. She said she had gotten several answers ready over the years and had thrown all of them out, and that the only one she had left was not very good. "Everybody wants the apology," she said. "I wanted it for 41 years, and I got one. 6 pages, in his own hand, and he did not spare himself one time in it, and he named the dates, and he wrote down the reason, and the reason was ugly, and he wrote it anyway. And I want to tell you the truth about that, because I don't believe anybody ever tells the truth about this part." She let it sit. "It did not give me back one day. Not one. Not 1984. Not 19 years on that line. Not my son on a bus at 20 years old. And the apology is for him. That's all it ever was. He needed it, and he got it. And I hope it did him some good. And I mean that. And I am not being smart when I say it. But when I stood up in that rotunda, with those 6 pages in my hand, I had exactly 2 things I could do. I could spend that room on a man who was past reaching, or I could spend it on the box in the barn. I want you to hear the difference, because it took me a whole night at a kitchen table to find it, and I am not certain I would find it again. Don't spend it on the apology. Spend it on the thing that's still broken." She is always asked the last question. She always answers it the same way, and she has never once dressed it up. "Have I forgiven him? I'm working on it," says Hattie Robel. "It's slow, and I'm not going to lie about the pace.